So let's bring in here Bran, Chief Executive of the Business Council of Australia, which represents the nation's biggest companies. Bran, always good to chat to you. Trying to work out what is reasonable or unreasonable, it just is impossible for any reasonable person to work out.
Well, certainly, thank you very much for having me on the show. It's great to be here. Look, I think you hit the nail on the head before when you were talking about how challenging it can be for employers in these circumstances. The simple fact is that this right to disconnect is a right that came about in France and in other European jurisdictions, but most importantly, it was pre-COVID. And what's happened post-COVID, it's that we've seen flexible working, we've seen the way that we work change in a really significant way. And this is yet another example of a real top-down, one-size-fits-all approach to the Australian economy. And we know that doesn't work. To your point, we've got to move back to this idea of having enterprise-level bargaining between employers and employees, because we know that that's how we deliver productivity, and that's what the country desperately needs.
OK, but then, given the fact that so many people now work from home on a more regular basis, this whole notion of what is encroaching into the work-life time becomes very difficult, because you know that there are employees, whether it's reasonable or unreasonable, doing chores that they wouldn't have otherwise done had they gone to work.
Well, I think that's right. And you would have seen, just as I have, that many people set notifications on their emails saying, I'm contacting you because it's convenient for me. I don't expect for you to be able to respond until it's convenient for you. I think that just emphasises the point that we see that workplaces do entail much more flexibility now in their approach to managing their employees and to managing their workflows. And again, it goes back to this idea that you don't need a top-down dictate in terms of applying this type of provision. Instead, do what used to be done with respect to rights to disconnect and negotiate at that enterprise level. Now, I should stress, we're not opposed to the idea by any stretch that people should be able to switch off. We think it's critical. I know when I get home, I want to switch off. I'm sure you do too. But at the end of the day, we know that the best way to deliver the flexibility that workers are looking for and the productivity that employers are looking for is by having those enterprise level discussions.
But then you and I both know that if something happens that causes somebody to ring us up out of hours and say, this is on, you need to be here now, you do it because that is your job, right? So therefore, this notion about just being able to disconnect and just completely and utterly ignore what might be urgent, again, it comes back to that judgment of what's reasonable and what's not.
That's absolutely right. And we saw during the discussions with respect to this law that there were so many other examples that presented challenges in terms of implementation. For example, if you're in Western Australia in summertime and you email your colleague in New South Wales at 3 o'clock in the afternoon your time, what does that mean in terms of whether or not you've done something that's of concern in terms of your company's exposure to a liability? Now, this is one of the many issues that employers have had to work through and are in the process now of having to work through as a consequence of this law being implemented. But again, it goes to the point that from a reasonableness perspective, you've got to look at it at an employer by employer level. You have to have that employer by employer perspective and account for the specific needs of different organisations. And that's why, as I say, the best thing that you can do, if you're going to go down this path at all, is operate at the enterprise level.
And it seems as though the government putting a framework around the notion of casual work. They're doing that separately from also these rights to disconnect.
Well, yes, that's absolutely right. So we've seen that a new definition of casuals has been brought in. And to put some context around that, we've moved from a position where we had a very simple, a very easy to understand definition of casuals. It was effectively what the words of the contract said to now a 3-page, 15-part test. That makes it really difficult for employers. And not all employers have large, well-resourced human resources departments. A lot of employers, particularly smaller employers, need to be able to work through the law and understand what its implications are for themselves. And when you've got these highly subjective, open to interpretation definitions, like the definition of casual work, like the definition of what is an employer and employee, that's also changed. It just makes it hard right across the economy. And our concern is that what that translates into is a reluctance on the part of employers potentially to hire some staff at all.
Yes, and it's a terrible thing if that's what it comes down to as well. Bran Black, always good to have on the program, and many thanks for your time today.
Thank you so much.